Shelley Silver was both using his position to direct tax dollars to a mesothelioma doctor in return for kickbacks, and that he created an apparatus that shielded him so completely that he could systematically deny women their human and legal rights. These two things are related. And they're not, I think for a lot of people, we understand them differently. Oh, corruption, public corruption, that's about violating the public trust and ethics. And it seems like an abstract notion where there maybe aren't tangible victims. Like, the public trust is violated, what is that? Whereas that is a way in which he was able to really just like steal and make millions of dollars off his political position rested on a certain understanding with his membership. This centralization of power, and certainly that is related to an old boys network, where this sort of eye-rolling around inconvenient women is something that everyone can sort of get over fast as long as they are rewarded with a proper Lulu, with a good committee chairmanship, and so who cares about a few broken and brutalized women? We can all get past that as long as the policies we're passing get us reelected and keep us fat and happy. And so that situation is exactly the circumstances that breed the abuse of women, and a really disregard for women's well-being, safety, and frankly just personhood in the workplace. So I want to also add that, you know, when Leah and Rita came onto the scene, you know, we know that this is not the first time in that office that they were reporting abuse, actually. There was a Jane Doe before them we have today with us, Elizabeth Crothers, who 17 years ago came forward to report a rape. And the fact that that was something that could be swept over the rug, that literally, you know, the man who raped her admitted to it in a settlement agreement, admitted to having sex with a woman without her consent. I don't call that anything other than rape, but everybody in here could sort of be okay with it. So being okay with the systematic deprivation of women's rights and personhood in the workplace is related to the corruption that allows a male-dominated patriarchy, because that's what this is, to rob New Yorkers blind as well, because everybody has to be okay with it. That's what I think.
It blows me away. Because when you think about it like that, it's an indictment of the entire system that we live under. Sarah, you got involved in this early to help write new legislation when you were asked by another attorney to weigh in. I don't want to talk about the early stages. I want to talk about the day your head exploded. Because it's a very specific day and a specific turning point in the creation of this new legislation.
Sure, thanks, Susan. Anyone that knows me knows that that's one of my favorite expressions to say. This caused my head to explode. And it happened the day that I was sitting in my office and was informed that the state Senate had passed a bill sponsored by Senator Kathy Young that defined sexual harassment as being only sexual in nature. And the problem with that bill was that it was walking the law back a good 30 years or maybe more. Sexual harassment is not just sexual in nature. And it was that day when it really hit me hard, and I realized that there was a severe lack of understanding in our state legislature about what sexual harassment is. Sexual harassment is a legal term of art that's grounded in sex-based discrimination. And this goes back to the 1964 Civil Rights Act, which was signed into law by President Lyndon B. Johnson and prohibits employers from discriminating against women on the basis of their sex. And from 1964 forward, we saw development in case law, and it wasn't until 1986 that the United States Supreme Court found that sexual harassment even really exists. There are two forms of sexual harassment. There's what's called quid pro quo sexual harassment, which Leah described a little bit of her experience, which is this idea of, well, if you do this for me, I'll give you that. And if you don't do this for me, I'll do this to you. You know, like she described what happened to her. That's what quid pro quo sexual harassment is. The other form of sexual harassment is what's called hostile work environment, which also is a legal term of art, but many of us hear it and refer to it often. But what it is it has to be grounded in some form of discrimination. And to put it simply, that's the sort of what you commonly refer to as, you know, like grabbing a girl on her ass at work, or
tell them about the construction worker.
Oh, well, so to give an example of something that's not sexual in nature, let's say you have a woman that works in an industry that's not typical for women, like construction, for example. And the men that she works with sort of toy with her. Maybe they hide her tools and take them away from her, or interfere with her work by giving her a different uniform, or in other ways singling her out. That's also sexual harassment, but it's not sexual in nature. So that type of conduct also has to be addressed in legislation, and which is why my head exploded when I saw the definition as it was.
So when you say it walked us back 30 years, basically it would have hurt you, this definition. The way you're a lawyer who litigates sexual harassment cases. If this had become law, but it didn't,
Correct.
If it had become law, how would that have affected you and your clients?
It would have affected us in a big way, which is why, for me, it was a call to action, and I immediately dropped everything and got myself involved, because outside the 5 boroughs of New York City, what the New York State human rights law does is protect all employees in the state of New York. And it applies to all employers in the state of New York, regardless of size, but only with respect to sexual harassment. I won't confuse it too much, but just accept that for what it is. So for any client that I'm representing in upstate New York that works for an employer with less than 15 employees, Title VII only applies. The federal law I described, the Civil Rights Act, only applies to employers that have more than 15 employees. The state law applies to everyone. So anyone that works for an employer smaller than that, that's who we're looking at protecting in all of New York State through the New York State human rights law.
Senator Krueger, how is it that there's a body, the state Senate, with God knows how many lawyers that would allow this bill that used language from the 1974 civil rights law? What?
76, 78, somewhere around there.
All right, 70s, yeah, when Carter was president, or, you know.
That's fair.
How does that get through?
So the New York State Senate is fairly infamous for bills popping up, going immediately through the Rules Committee to the floor for a vote, literally in one day. And so I can't remember whether it was 2 days or 1 day on this one. But I knew it was bad, but I don't pretend, I'm not a lawyer, and what I try to do as a legislator is to realize how little I know, which just means I have to go find the smart people to talk to so that I do understand. And that was actually the case in this situation, realizing how this would actually set us back 30, 40 years legally. So I actually didn't remember. Am I the only one who voted no?
It was you and Senator Brad Hoylman.
So yeah, Brad Hoylman and I both voted no on the bill, recognizing the damage that would be done here. And the whole concept for me when thinking through sexual harassment law policy is to not actually internalize that somehow sexual harassment means I like somebody and I'm being inappropriate and they object. It's a power imbalance and control situation. I try to internalize it much more as if when people talk about rape, and sometimes harassment gets to the level of rape, but that rape is not a sexual act, it's a power and control. an anger act. Yes, a sexual crime is taking place, but it's really about the perpetrator's mindset of control, power, violence, and that sexual harassment needs to be thought through in the context of employment and professional relationships as, is there an imbalance of power? Is there a level of control and dominance that is being played out in exploitation of the other person? And so it was very clear to me, even though I knew what I didn't know, that Kathy Young's bill absolutely wasn't going to be addressing where we needed to go in New York State. And again, for me, as I said before, this is about making sure that when victims need to come forward, that they are encouraged to do so, but also encouraged to know exactly what steps they should be taking, as opposed to, I feel like I'm wandering in the wilderness of like,
do I go to this board
something.
or this board or that board? And we actually have an opportunity now, because of the Times Union's investigation of the Division of, thank you, Criminal Justice Services, that we can see how convoluted and ridiculous the system is, and that it hurts people.
It hurts real people throughout the state of New York all the time. And I guess I will just throw in, it doesn't just hurt the victims, it hurts everyone. So for us to believe that we have a state government where you can be employed at almost any level in New York State, and if something like this is happening to you or a colleague of yours, that there's the potential that there is no answer or solution for them about what's going on. And guess what that does? It reinforces, not only can the perpetrator continue to perpetrate on others, as Leigh was describing in Assemblyman Vito Lopez's office, but it also sends a message to other folks who are observing this go on. Oh, actually, apparently this is okay here.
Why should I speak out?
Well, one, why should you speak out? But for others, oh, I probably can get away with this too.
Sure.
Right, so it's actually, it's imposing a culture of acceptance of this all as normal, which I think goes back to Leia's earlier point and Alexis's point about Me Too and the importance of speaking out, because it is a pervasive and very damaging culture.
So I want to create a time chronology here. So this bill that set us back 30 years did pass the Senate.
But didn't pass the Assembly.
It did not pass the Assembly.
Correct.
Okay. So somewhere between lip and cup, there was a conversation